Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution and this honorable court.
Very good. Good afternoon. Welcome to the First Court of Appeals on Zoom this afternoon. We have one case on the docket today. It is 01-22-00396 CV, in re CJS, a child. Starting with the appellant, will counsel please make their announcements?
My name is Sally Smith, and I'm here representing Zachary McNeil.
Carrie Westbrook here for the appellee Victoria Stern.
Very good. Each side today will have 20 minutes to present argument total for each side. Does the appellant wish to reserve time for rebuttal?
I've reserved 5 minutes, Your Honor.
I'll write that down. Very good. Before we begin, as you know, and you've done this before, I'm sure there's 3 lights. Green light obviously means start. The yellow light is an indication that you have 1 minute left in your allotted time. The red light, of course, means stop. If we're asking you, I've asked you a question and the red light goes on, please continue. You don't have to stop. You can finish your answer even though the red light is on. Also, let me state that we don't need a recitation of the facts of this case. It's complicated, but we've read the briefs, we've read the record, and we're familiar with underlying facts. So it's most helpful for us during this short time if you can dive right into the legal issues. And with that in mind, we'd ask the parties today if you could begin your argument focusing on the jurisdictional issue. So with that in mind, we're now ready to proceed and hear from counsel for appellant.
Thank you, Your Honor. Focusing the arguments on the jurisdictional issues, first and foremost, as governed by the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, is critical because it impacts a variety of other issues raised in the case, with the exception likely of Zach's paternity. Both Texas and Louisiana have adopted the UCCJEA, and the statutes that are relevant to your decision are virtually identical in both states. The trial court took judicial notice of the Louisiana statutes during the post-judgment proceedings. And as you're aware from the exhibit that was filed by Victoria's counsel on Friday, Louisiana has twice taken jurisdiction of the custody dispute between these parties. It has worked its way through the appellate system with an affirming decision at the Third Circuit Court of Appeals twice, and the Supreme Court twice in Louisiana, with the last denial of review occurring last Wednesday. The Texas court order is in direct conflict with those decisions. And under the de novo standard of review that applies to subject matter jurisdiction issues, it allows you the opportunity and the obligation to analyze the facts that are available to you in this record and to construe the statutes and make findings that are completely your own for the very first time, not even giving deference to the Texas trial court's decision. Because the UCCJEA gives...
So you're suggesting that, are you telling us that we can make our own findings independent of what the trial court did?
I think that you can look at the facts and you can analyze those facts and apply them to the law and the statutes as you construe them. De novo, completely as if you are standing in the shoes of the trial court. Yes, sir. And I think because the UCCJEA gives priority to home state jurisdiction, the place that is the most important and the most critical to begin is with the definition of home state. Under 152-102 subsection 7, for a child less than 6 months of age when a suit is commenced, which is the circumstance in our case, it defines home state as the state in which the child has lived from birth with a parent in this case. And
Smith, and I'm sorry to interrupt you, just before we leave the standard of review.
yes.
And as it concerns the facts that we are reviewing, to the extent that there is some controverting facts in terms of where Ms. Stern was residing or where the child was living, what deference do we give the trial court in this de novo review of jurisdictional issues?
Well, I think clearly the trial court is the final decision maker in terms of the facts. The trial court in this particular case looked at the various dates that the parties claimed the child and the parent were present in Texas versus Louisiana and analyzed those. There were further stipulations in Louisiana that you don't have the benefit of, but even recognizing some of those dates, I think construing the statutes in the way that I am going to argue they should be construed will still reflect that Texas did not have jurisdiction, even if you give deference to the findings that the trial court made.
In our review of those facts that were before the trial court, the Texas trial court had a plea to the jurisdiction hearing initially and then made a ruling. And subsequently, when your client filed a motion for reconsideration, there was additional testimony elicited during the hearing. There were also some affidavits attached to the motion, and the trial counsel at that point requested that the court take judicial notice of some things. So what we need to get your guidance on is what specific evidence, separate from what the Texas court considered during its original plea to the jurisdiction hearing, was before the trial court properly for her consideration of the jurisdictional issue.
And are you referring, Your Honor, to the affidavits in connection with the motion for new trial?
Two things. There were the affidavits that were attached to the motion for reconsideration and the motion / for new trial. And separately, the trial transcript from the jurisdiction, from the Louisiana court that Mr. Stern's counsel asked, Mr. McNeil's, I'm sorry, counsel asked the trial court to take judicial notice of.
And
I guess the real question is, was that hearing transcript properly before the Texas trial court? Was it correctly admitted, and was that evidence before the trial court for her consideration of the jurisdictional issue?
I thought that transcript was specifically admitted into evidence in addition to it being attached as an exhibit to the post-judgment motion. I can certainly check and clarify that.
Well, maybe I did. To help you out in that respect, the question I'm having is the trial counsel at that point asked the court to take judicial notice of the transcript, and the court then admits it. But to me, asking the court to take judicial notice is different than putting the evidence before the court in terms of the court's consideration of the jurisdictional issue.
I understand the difference, Your Honor, and the fact that you can take judicial notice that it occurred. I believe, if I'm not mistaken, that the transcript of the first Louisiana hearing was made part of the mandamus record that was filed by Mr. McNeil's original trial counsel, and that we asked the court to take judicial notice of that record as part of these proceedings, which is certainly allowed. And so that record would have been before this court, judicially noticed as part of the mandamus record involving the same parties.
Right. I guess the question, though, was it judicially noticed in the trial court? So was it admitted before the trial court, Judge, or was it just simply judicially noticed?
I thought that it was admitted, Your Honor, but if it was only judicially noticed, I still believe that there is plenty of evidence in the record that to establish the facts that this court needs to consider in construing the statutes and determining the jurisdictional issue. And what that requires the court to do is to look at this definition of home state for a child less than 6 months of age, which is where the child lived with a parent from birth until that suit was filed. And it also specifically says right after that the temporary absence of a parent shall be considered part of that period. So clearly the court acknowledges and understands that the disputed issues of where Victoria lived is a critically important decision in this case. And aside from her conclusive statements that she lived in Texas, I think that that is supported merely by periodic visits that she made to visit her older child here. But I think contrary to that, the record in this appeal before the trial court truly genuinely establishes that she lived in Louisiana since 2017. She came here briefly in 2020, but was only here 3 or 4 months before she returned. And she entered into an agreement with the father of her second child, which required her to live in Louisiana. She leased an apartment there. She had a job there. She had a driver's license there. She had her prenatal care there. She did temporarily come to Texas to give birth to the child. And then she returned to Louisiana, where she executed documents under oath stating that's where she lived. She also got
Miss-
government.
Can I ask you a question? Because you're talking about
Absolutely.
this issue. The statute talks about where the child lived with a parent. And there's a lot of focus placed in the appellate briefing on where mother's legal domicile was at or where she was a resident. But is that what the statute requires, or are we just looking at the definition of home state, which states where the child lived with a parent? In other words, do we really need to, it seems to me that there's a lot of focus on the domicile, the legal domicile of the mother, as opposed to where the child was living with either parent.
I think that the intent, as far as intent is concerned in determining residence and domicile, is not relevant. I think the physical, where they lived is what's important. And I think the actual reality is that she truly lived in Louisiana. The Supreme Court in Powell versus Stover, a 2005 decision, talked about how the word live, as specifically used in the statutes, does connote a physical presence, but they refer to a Webster's definition, a Webster's dictionary definition, which talks about actually staying in a home, living in a home. And so I think that still the evidence all points to Louisiana. And I think the reason why that is so critically important is because the definition statute says, expressly says, the temporary absence of a parent counts towards this period. And if you, there are multiple appellate decisions across Texas that deal with the, that focus on a temporary absence of a child from a state. Those are all under 152-201A of the statute, which talks about once home state is determined, if it was home state within 6 months of the suit being filed, that the temporary absence of a child does not matter as long as one parent continues to reside in Texas. But we're looking at a different.
Why does that not cut towards affirming the decision of the Texas court? If the child was born in Texas, lived here continuously for 5 weeks, was absent for some period during the February and March months, but once mother returned, she remained here. So why are those periods, those temporary periods that mother was in Louisiana following the child's birth, not factor into these temporary absent periods under the definition of home state?
I think that if you determine under the facts, as Louisiana did, that mom lived in Louisiana, if you look at it from the Louisiana perspective, and their statute is identical to ours in defining it, if you determine she lived in Louisiana, her temporary absence from Louisiana to come to Texas and give birth counts as part of the period from birth to the date suit was filed. As best I can tell, this would be an issue of first impression in Texas because 152-1027 expressly states temporary absence of a parent. We're looking at Victoria's absence. Was she living in Louisiana and absent coming to Texas temporarily, or was she living in Texas and was absent to Louisiana temporarily? And I think all the evidence conclusively supports that she was living in Louisiana. Even her own under oath statements say that she was living in Louisiana. And so if you look at it from that perspective,
Ms. Smith, why are we constrained to look at it from the perspective of the Louisiana court if we're reviewing the Texas court's decision?
Because I think the Texas court was under the same obligation to look at the definition and say, here is all the evidence. If I determine where she lives, and of course, clearly the Texas court found she lived in Texas. We disagree with that the evidence doesn't support it. And if it's the overwhelming evidence is to the contrary, because those statutes are the same, you would still consider her temporary absence from where she lived in Louisiana as defining this child's home state. And that
did the Louisiana court actually do the home state analysis? I thought that they did not. Only the Texas court did that.
the very first decision in Louisiana doesn't say one way or the other, but references in the transcript Judge Earle's comment about the child's significant connections, which is the second priority under the UCCJEA. But certainly the second decision by the Louisiana court makes a clear finding that Louisiana is the child's home state, and that is the Third Court of Appeals opinion from September of 23.
But that would have been after.
That affirms that.
That would have been after the Texas court made its determination.
It
correct?
is, but I think in your de novo review of these issues, I think that you have the opportunity to look at these matters. And yes, you're going to be looking back to the date both of these suits were filed. But I think that when you look at those dates, Louisiana was filed first. That has some impact. And I think even if you were to determine ultimately that the Texas court made the right call on home state jurisdiction or significant connection jurisdiction, I think there is a third reason why Texas made a mistake, and that's 152-208 of the Family Code, which is the unjustifiable conduct statute. Under that statute, Ms. Stern was here in Texas when she filed suit with the child in violation of a Louisiana court order. She had been served several days before and was in violation of that order by removing the child from the state and bringing the child here.
I got one more question for you, even though you're at zero time here. The overwhelming evidence that you just referred to goes against you argue the trial court's finding of a home state. Is that overwhelming evidence? Is that the evidence that was attached to the motion for reconsideration and for new trial, or what is that overwhelming? Where is that overwhelming evidence located?
We refer to all of that in our brief. All the details of that are found between pages 30 and 33 of our brief, which detail the items in the record where all that particular evidence can be found. Some of that bears on stipulations that the parties made, despite the sort of number of days that they were disagreeing. The child was in Texas versus Louisiana.
Okay, so the last question, then going back to where we began on the de novo review, you're saying we get to reweigh that overwhelming evidence and decide which way it goes. Did I understand that correctly?
Yes, sir.
Okay. Are there any further?
I know this because this is important. If under the definition of home state in the statute, is there a possibility of there being two home states? And if so, then do we have to analyze a significant connection jurisdiction?
I think the UCCJEA is designed to prevent the existence of two home states. There could be no home state, certainly, but I don't think it necessarily contemplates that there could ever be two home states so that you go to the significant connection. I think too that so much emphasis is placed on birth, the from birth, but I think if the legislature had intended the place of birth to define home state for a child less than 6 months of age, it certainly would have said so, and it didn't. And it said that the parent's absence from that state is included as part of that period. And I think that that's why your construction of the home state definition, possibly as an issue of first impression, where from birth, the absence of the parent is considered on the front end from birth in this case, still considered as part of her residence in Louisiana, that supports actually home state in Louisiana.
Thank you.
And it is complicated, I understand.
Are there any other questions from the rest of the panel? Well, very good. Your time is up. We appreciate your argument. We'll hear from the appellee now, and then we'll hear back again from you on rebuttal.
Thank you. I wanted to start out by addressing the question from the panel, or the questions about the review. So this court in re Meekins, which was also followed by a number of cases in Texas, including in Ray Drake out of San Antonio, specifically found that an abuse of discretion does not exist if the bases of its decision are conflicting evidence and some evidence supports the decision. So I don't agree that that is supposed to be reviewed de novo by this court. The facts that the trial court in Texas determined are binding on this court because those facts were conflicting. Our court heard both sides of the coin, and the court ruled in favor of Ms. Stern. I don't believe, it's not that I don't believe, it's that your own cases say, as well as other cases in Texas, stand for the proposition that you cannot, as the appellate court, review those facts and overturn that court's decision, even if you disagree with the way that they came down on the facts.
Ms.
So
West, what's the citation that you mentioned?
it's in Ray Meekins, Your Honor, that was out of the First Court of Appeals. And then in Ray Drake, which was a San Antonio case that followed in Ray Meekins.
Thank you.
Now, in terms of the issue about the
Actually, let me, before you go on to that, as long as we're on standard of review, we ended up with the appellant and we were talking, I asked her about the standard of review, and it sounded like she was saying there was overwhelming evidence that pointed toward Louisiana, and that we get to, according to her argument, and that we, under her version of de novo review, get to reweigh the evidence and make a new finding based like a finder of fact or a trier of fact. Do you agree with that description of the standard of review?
No, Your Honor, I don't, because that line of cases that I was pointing to specifically says that under it, the facts have to be reviewed under abuse of discretion, such that the trial court's decision on those contested issues can't be disturbed on appeal. Only the law can, of course, be reviewed in terms of how the law was applied to the facts. That's de novo, but not in terms of determination or credibility of the witnesses and the evidence. Now, in terms of the home state issue, I believe that that is the primary concern here. Our court, or the law does specifically state that if the child is born in the state and resides here with a parent, that home state jurisdiction attaches. I apologize. So it doesn't matter, or it's not relevant to this court's determination of home state where the child may have traveled once that initial home state jurisdiction attached after the child was born in Texas and remained here the first 5 weeks of its life. Following that period, when the child began traveling back and forth, that does not negate the home state jurisdiction. If that were the case, the child could move to 6 different states during that period, and 6 different states would, the home state jurisdiction would travel around with the child, and that's clearly not what the statute would have intended. The statute.
What about Ms. Smith's argument, though, that if we are that narrow in constraining the statute, we're essentially holding that the home state is where the child is born. So, I mean, how far back before the child was born? I realize the statute says at the time that the proceedings were commenced, but do we have to look at some context? I mean, I know that mother had been in Louisiana right before she had her child. Is that right? In fact, she traveled right at the cusp of giving birth to her child, to her son, and remained in Texas for 5 weeks, but then she returned where she had primarily resided for some time in Louisiana.
The evidence that we presented showed that she moved back to Texas to live with her father and stepmother in 2020 due to COVID. She had a job in a bar in Louisiana. That job, the bar was shut down due to COVID, and she returned back to the state of Texas to live with her parents at that point. She traveled back and forth routinely because of the fact that she had another child in Louisiana for which she was given possession and access schedule, but she also had a third child in Texas for which she had a possession and access schedule. So she routinely traveled back and forth between both states. And then she testified that she had moved back to Texas approximately 3 months prior to the birth in order to be able to have the child here, have assistance and support from family after giving birth to the child in question in our case. And after that, of course, and the 5 weeks went by, and then she began resuming the travel back and forth between the two states. However, I will point the court to In re Burke, which was from the 14th Court of Appeals. And in that court, or in that case, the child there was only in the state of Texas about 3 months post-birth before the mother moved to Colorado to be back with her family, took the child with her. And approximately 3 to 4 months after that, the father filed for jurisdiction in Texas. And the 14th Court of Appeals held that home state jurisdiction attached in that situation. Unfortunately, there's no bright line rule as to how long the child had to remain in Texas post-birth. And I do believe that the way the statute is worded does entail that the child remains in Texas for some period of time. And in re Meekins, this court reemphasized that point and said, the period, as long as the child's born here and they remain here for some period of time, that's sufficient to establish home state jurisdiction. And the other
to assist us in making that determination, key to our analysis is what evidence was in front of the trial court. I mean, we clearly know what evidence the trial court considered during the plea to the jurisdiction hearing in April. The question that I have for you is, what evidence do you agree was before the court on the issue of jurisdiction when the motion for reconsideration was filed? Was there additional evidence the trial court considered on the issue of home state, and what evidence was that?
I do not believe that that our Texas court considered any further or additional or new information in the motion for new trial hearing. Everything that from the record supports that the trial court heard that at the initial hearing on jurisdiction, where Mr. Bosker and Mr. McNeil declined to participate. So, and in terms of the judicial notice question, I would agree with the court's analysis that if those documents were merely taken judicial notice of, as opposed to actually being entered into evidence, then our court here cannot consider that information as evidence. There was some limited testimony in the motion for new trial from the Louisiana counsel for Ms. Stern. So there was a little bit of information just in terms of the procedural history that had evolved since that first hearing in Texas about jurisdiction. So I know that our court in Texas took that into account, but I do not recall there being new facts set forth in the motion for new trial that were not already presented to the court initially, other than through the, those same judicially noticed documents were essentially before the court for all purposes, because our court in Texas, let me strike that. They were not before the court for all purposes, but they were already judicially noticed by the Texas court because the Texas court had taken judicial notice of the mandamus attachments. And Ms. Smith did correctly state those were attached. Some of those Louisiana documents and the orders and pleadings there were attached there. However, there is a distinction between judicial notice.
Or maybe I should have asked Ms. Smith this, but what was your understanding of why those documents were judicially admitted?
I don't know that, I don't believe they were ever admitted into evidence.
I'm sorry, judicially noticed, right?
The court took judicial notice, and there was basically Ms. Smith had argued that there was a particular statute that allowed our trial court in Texas to take judicial notice of the other proceedings and pleadings that had been on file, and our court agreed to take notice under that. And I apologize that I don't know the statute off the top of my head, but I can find that out. So I believe at that point that was, at that time, I don't believe that evidence was actually admitted into evidence. It was simply just something the court took notice of. But I would say this, that the court here correctly points out the Louisiana judge never conducted a home state analysis until, as Ms. Smith stated today, 2023, which was well after the home state jurisdiction in Texas had attached. And under 152-201, once home state jurisdiction attaches, Texas maintains that continuing exclusive jurisdiction until one of the other bases of jurisdiction is met, in some other way, such as if our court were to determine, look, at this point, the child and the parent don't have a significant connection with the case or with Texas any longer, or if they were to determine there's not substantial evidence in Texas, they could then say, I'm going to cede that home state jurisdiction. But they never made that determination. And in fact, it was the other way around. They found they had home state jurisdiction in Texas. They tried to confer with Louisiana due to the simultaneous proceedings, and the Louisiana judge did not follow the law in having that conference. The Louisiana Supreme Court, in the letter that I submitted as Exhibit A to the court before argument, did find that judge erred in Louisiana by not conducting the home state analysis. They recused that judge, removed him off the case, sent it back down to start essentially all over from square one, to have a new judge review everything. And that's where we ended up finally in 2023 with a finding that Louisiana had home state, but that was well after Texas had already had home state and continuing exclusive jurisdiction.
Counsel, let me ask you this. In a case like this where their home state analysis didn't occur in the first filed suit until after the home state analysis occurred in the second filed suit, how does that cut? How does that work? Does the first filing act as a placeholder? And then it just, whenever that home state analysis occurs, it kind of accrues back to the first filing? Or does the fact that they didn't do the home state analysis kind of knock them out of first filed status, if you're aware? I realize that's very specific.
That is, Judge. Unfortunately, the statute, the UCC-JEA statute as adopted in Texas, it's under 152-201A, or 152-201. It specifically addresses that issue, and it says the relevant period of inquiry is only from date of birth until date of commencement. Well, it could also be 6 months, but in this case, our child was less than 6 months. So it's only from date of birth to date of commencement of the initial custody determination. And that's extremely important because in general civil law, there's issues about wherever you file first, you may be able to acquire jurisdiction, but it's different under the UCC-JEA, and it's a very important distinction because the UCC-JEA, as 152-201 states, is the exclusive means for a court to acquire jurisdiction over a child custody matter. So it's a very specific statute just to child custody matters. And the reason that it's important that the statute even goes in 152-102, it defines all sorts of terms, including what is an initial determination. And that talks about how that it is relating to the first filing. And this is segues into my argument about why Louisiana still couldn't properly obtain home state jurisdiction in 2023, because it goes back to the initial commencement period of the first lawsuit. And if for our purposes, it even specifically says it's the commencement date of the suit in Texas. So we don't even look at the commencement date of the Louisiana suit, which was, a few days before the Texas suit initially commenced back in March of 2021. But that is a very important point, a nuance to things that is important to understand because it is so unique in this area of law, and it sort of goes, it's different than how a general civil case would be handled, where it's kind of first filed, first served controls. It's not like that for purposes of this type of jurisdiction.
Ms. Westbrook, what is your response to Ms. Smith's argument that regardless of home state or significant jurisdiction, the unjustifiable conduct standard under 152-208 would preclude the Texas court from having jurisdiction? Ms. Stern did leave the jurisdiction of Louisiana in violation of the issued TRO. How does that come into play in our analysis?
I believe that analysis is not relevant to the facts before this court, because if you review 152-208, it doesn't apply in this case. 152-208 requires that the court having another order has proper jurisdiction to enter that order. It was Ms. Stern's position throughout this matter, as well as our position here today, that Louisiana never had proper jurisdiction over Ms. Stern. Therefore, that order that they issued was wholly void. And it was not the type of conduct that would violate that 152-208 contemplates. She did not commit some fraudulent or, bad acts that would warrant the application of 152-208. She felt that Louisiana did not have jurisdiction. She sought counsel here and she initiated a suit here. She left the state with the understanding and belief that that court did not have home state jurisdiction over her or her child. So if that is the basis of the unjustifiable conduct, which, by the way, there wasn't really evidence fleshed out about that by the appellant in the trial court, but even if that were the basis, the court here did not make a finding that there was any unjustifiable conduct, because the court here made the finding that Texas was the home state and that the Louisiana orders therefore were void and did not apply to our client or to the child.
Was that unjustifiable conduct argument made to the trial court in Texas?
The only time that those words were mentioned, if I am recalling correctly, was in the motion for new trial hearing. As an aside, at the very end, they kind of threw out that word unjustifiable conduct. That was the only time that was mentioned until the appeal, that was mentioned in their brief as well. But I don't recall, there was not extensive evidence or argument put on about that issue in the Texas trial court. And the other issue is that there was a lot of unjustifiable conduct on both, on the other side, where Mr. McNeil had taken the child pretending to just visit, got in the car, drove off, and basically never let Ms. Stern see the child again. Those facts are outlined in our brief. So, but that simply wasn't in our mind. That statute is inapplicable altogether, because it entails that the Louisiana court had the authority to issue such an order in a child custody matter over CJS, which it's our position it did not. So she can't have unjustifiably left the state in violation of an order that should never have existed, because it wasn't proper to begin with.
So as we review the trial court's findings here, the evidence that we need to look at, if I can remember what you said earlier, is you said that the only evidence that was admitted before the trial court was when it made its initial ruling with respect to the at-home state, and that there was no other evidence, no new evidence admitted after that. Is that correct?
Correct, Your Honor. The only new evidence really was going to the issue of the default judgment and the Craddock factors and issues related to that part of their motion for new trial and the motion to set aside the default judgment. So there were no new facts. We certainly discussed the home state. We had some ancillary discussions on the record during that final hearing on the new trial about that issue, but it was very on the fringe. There wasn't any new evidence submitted either way about that issue. All of the evidence that was submitted was in that initial hearing. I believe it was in April of 2021 when our court first determined to take jurisdiction. Oh, I'm sorry. I think there were two hearings. There was April. The trial court convened to talk with the Louisiana judge, and then she reconvened the hearing in September when that court in Louisiana did not choose to speak with her. So I believe the 2021 September hearing was really the only hearing, the last hearing at which that evidence was presented. Other than in the default hearing, I did go back through testimony with Ms. Stern, and she testified about some of those home state issues. But of course, the appellant was not participating in that hearing at that point, so they didn't present those issues at that time.
So
I'm sorry, go ahead, Chief Justice.
I'll let you go ahead and I'll follow up after you.
Yeah, so when you say that the evidence that was submitted at the hearing for new trial was mostly geared toward the Craddock factors, one of those factors is whether there was a viable defense, and the viable defense that they were advocating was the lack of jurisdiction. So the evidence that was judicially noticed, or the affidavits that were attached, did in some respect go into the jurisdictional issue, which itself was the viable defense under one of the Craddock factors. So if that is the case, then is the court then allowed to consider that evidence? And are you saying that it can only consider that evidence with respect to the Craddock factors, but not jurisdiction?
I believe the way that occurred in that last hearing on the new trial was they asked our court in Texas to take judicial notice of those facts. They attached to their motion for new trial under that Craddock prong, arguing that these various factors showed that Louisiana should have jurisdiction in place of Texas. But those were merely affidavits that they submitted to support to try to present a prima facie case to get a new trial. So I don't believe that the court can consider that evidence in terms of the jurisdictional inquiry. because that was not presented to the trial court prior to there being a default entered. And it wasn't even presented to the trial court in the motion for new trial in that context. It was merely presented as attachments to try to make their prima facie case that they were, quote, setting up a meritorious defense to the default judgment.
So was any of that evidence that was attached to the motion to set aside or alternatively to grant a new trial? I think it was like 50 pages of documents attached. Were any of those pages of documents admitted into evidence, or were they just judicially noticed?
Some of those documents, Your Honor, were admitted into evidence, and I can't recall off the top of my head if those were specifically about the home state. I don't think they were, but I don't want to commit to that without being certain. But if you look at the Reporter's Record, Volume 6, that contains the admitted evidence, or I'm sorry, the admitted exhibits from that motion for new trial hearing. So that would contain all of those documents that were actually admitted into evidence for that purpose.
Very good.
On that product factors, before we let you go, just Mr. McNeil, in advancing some motion for new trial, alluded to the representation of his trial counsel to justify why he was not present during the trial. Is there a case or citation that would assist us in determining whether the advice of counsel would not justify his absence from trial under the product factors?
Yes, there's several several cases, in fact, Your Honor, that were cited in my brief that I believe apply. One of those, it was the Padilla case, where essentially a similar situation. The attorney advised the client that the way that he had received the papers was not proper service, when in fact it was, because he had been served by allowing posting. The attorney misadvised him that it wasn't proper service, advised him not to respond. The client did not respond, but the court said, sorry, that does not excuse the conduct. It was still found to be conscious indifference, even though it was the counsel's mistake. And the other cases along those lines indicate that the counsel's or the trial counsel's decisions are essentially imputed to the party that they represent. But in this case, it's even stronger because we had specific testimony in the record at Volume 5 from the motion for new trial hearing from the trial counsel, Mr. Bosker. And he testified that he and his client made a strategic, specific decision not to appear at the new trial hearing, or I'm sorry, at the hearing on the plea to the jurisdiction. Once that was done, they opted not to appear for the temporary orders. And then they opted again not to appear for the final default trial. It was a strategic decision. So he talked about that in his testimony. And furthermore, that decision came after this court had denied their petition for writ of mandamus on the issue of subject matter jurisdiction. So it doesn't make sense they would still be arguing that they didn't understand the Texas trial court had jurisdiction when this court had specifically denied their petition for writ of mandamus on that issue by the time the default judgment was entered.
Are there any more questions from the panel? Very well. Well, thank you, counsel, for your argument. Your time is up. We're now ready to hear rebuttal from the appellant.
I believe you're muted, Ms. Smith.
Yeah, you're still muted.
Oh, okay. Is that
There you
better?
go. Yep,
Thank you.
we can hear you.
Touching on that particular issue that Justice Rivas-Malloy just asked about, the relying on the advice of counsel, there is case law that suggests that when a party relies on the advice of an agent, that you have to look to the knowledge and the intentions of the agent. And the appellee's brief talks about the cases that refer to action versus inaction. And the Supreme Court is very clear that conscious indifference means you were served with a suit, but you just really didn't care. And there is nothing about this case that indicates Mr. McNeil did not care. He did everything in his power to protect himself regarding the subject matter jurisdiction issue by filing the plea to the jurisdiction, by prosecuting the mandamus when it was denied. And the advice of his counsel was not a decision regarding their understanding of the law. It was a decision that his counsel believed he waived his right to assert that challenge through the appellate process if he showed up for trial. And so there is a plausible, justifiable reason why he was not there based upon the mistake of law that his counsel made. It was his failure to appear was an extension of his actions in preserving his rights to protect the subject matter jurisdiction issue.
Ms.
I
Smith,
want,
I
yes.
was looking at your brief on this issue, and I noticed that on page 13, you cited Bank One versus Moody, and that case in turn cites a bunch of other cases, and it doesn't seem like a uniform idea that just because an attorney gives bad advice, that excuses inaction in not showing up for a hearing and getting a default against you. I'm looking at like First National Bank of Bryan, Carrie Crutcher, and that one actually, Carrie Crutcher, involved an attorney who didn't understand how bankruptcy stays work. So I'm trying to figure out the unifying principle in terms of when inaction is permitted, if it's bad attorney advice and can be an excuse, and when it can't. If you could help elucidate that, that would be helpful.
I think that those cases that talk about the mistake wherein action was taken, such as the Board of Pharmacy versus Martinez case, where the attorney felt that venue was improper in a particular location and took the action of filing a motion to dismiss, similar to this case where the subject matter jurisdiction was an issue, and the plea to the jurisdiction action was taken to protect that. And then the mistaken belief that continuing to participate would somehow waive that. That was certainly a mistake, but there was action taken. There is nothing to suggest that even though failing to show up for trial was deliberate, that doesn't necessarily mean conscious indifference. And Mr. McNeil, was not consciously indifferent to this case and fought it at every level and continues to fight it because he believes that those orders are void for lack of subject matter jurisdiction. There are even cases in the appellate court where failure to answer based on the advice of counsel has been held as a mistake. So I agree there's not uniformity, but I think when you talk about action versus inaction, Mr. McNeil acted, and he acted on advice of counsel in pursuing this jurisdictional issue. His counsel has admitted in those hearings that he did make a mistake. He did interpret the law incorrectly, and that Mr. McNeil unfortunately relied on it to his detriment, leading to these consequences. I did want Justice Landau to answer a question that you asked in the earlier part of Ms. Westbrook's rebuttal relating to looking at what the Louisiana court has decided after the fact. The Louisiana courts of home state analysis still look to the March 4th, 2021 date as finding that Ms. Stern lived in Louisiana in advance of the birth. And in fact, the Third Court of Appeals opinion in Louisiana, which was decided in September of 2023, references the testimony of a witness that on page 1194 of that opinion, where she testified that Ms. Stern asked her to drive her to the Texas border if she went into labor because she didn't want to give birth in Louisiana and deal with its custody statutes, which is forum shopping discouraged by the UCCJA. So the unjustifiable conduct is still there. It is still present.
Was that testimony before the trial judge here in Texas or just in the opinion in Louisiana?
It is just in the opinion in Louisiana.
So not before the trial judge here.
Not when the trial court made these decisions, nor was it before the court. It occurred in the hearings that took place in Louisiana subsequently. I do want to mention, if the court would allow me, 152-206, the simultaneous proceeding statute, because it does come into play. And Justice Landau, you asked me earlier why you have to look at the Louisiana court's perspective of this issue. And it's because of the simultaneous proceeding statute, because 152-206A says the Texas court may not exercise jurisdiction if at the time the Texas suit was commenced, Another proceeding had been begun in another state that was acting in substantial conformity with the UCCJEA. And the Louisiana court, we believe, was acting in substantial conformity with the UCCJEA. And therefore, as a result, unless it terminated the Louisiana suit or unless it declined to exercise in favor of Texas as a more convenient forum, 152-206B required the Texas court to dismiss the conservatorship and possession aspects of this suit. And the court did not do so. So I think you do have to look and examine what was Louisiana doing and what was Louisiana thinking. And if you decide Louisiana was likewise acting in the appropriate manner under the UCCJEA, then as the first filed suit, Texas was required to dismiss because Louisiana was the first filed suit operating correctly under that statute.
Thank you, counsel. Are there any more questions from the panel? Well, thank you very much, counsel. Your time is up. Well, there you go. There's Counsel Frappoli. We wanted to thank both of you today for your excellent arguments and your briefing in this case. Very helpful to the court. Thank you again for doing this by Zoom due to the weather. I think that's better for everybody to be safe. And so thank you for that. And with that, this case is submitted and we are adjourned. Thank you all.